Hey, everybody. Happy Merry Christmas, right? It's Christmas time. Great Thanksgiving, Aaron. You had a great time?
It was wonderful, and I have an ongoing battle with my daughter. She wants to start the Christmas season before Thanksgiving, and I refuse. I'm very strict about it. And so now it's official. Yes, we can say Merry Christmas.
I have to say, we had all of our 4 children and our 9 grandchildren and all our daughters-in-laws with us for Thanksgiving, but we also did Christmas last Friday because Jenny and I will be on a cruise ship in Antarctica on December 25th this year.
You're spending Christmas in Antarctica?
Antarctica.
That's wild.
It's on a ship. We're not going to be on actually. You have to have special permission from Jesus to be on Antarctica, but we're going to be on a cruise ship. So just making it. Jenny and I normally do every other year is in-law Christmas. So it's when all the kids go to their in-laws. I don't know how we managed to do that, but we did. So this year is in-law Christmas, and we normally go somewhere fun.
Good.
And so we found a screaming deal on a cruise from Santiago to Buenos Aires. Last minute deal, so to speak. And so we're flying to Lima, although it's cheaper to fly back and forth from Lima and then take trips over to Santiago and Buenos Aires, then to fly to Santiago and back home from Buenos Aires.
Wild.
So sorry about that. I did not turn my my automatic Zoom phone call thingy on. So unfortunately, I have to wait till this guy is done. So he keeps calling. So I'm going to apologize. See if I can hang. Oh, here we go. I'm going to mark myself unavailable. There we go. Now it's done. All right. He's not giving up. There we go. Now he's done.
Somebody wants to talk to you.
Now he's done. So that's what we're going to be. So we won't be here till the start. We leave on the 14th for Lima. So we got a couple more weeks of our little lives here, and then we're out of here.
Good.
And I assume we'll suspend. Nothing good happens over Christmas. It's like there's Greg. It's like all good and bad immigration regulations come out on Friday at 5:00. So anyway, good morning, everybody. Hope you're great. Greg to join us. Greg, I was telling Aaron that I wore a hoodie because I thought Jesse would be here.
No, not her.
But I wore it to remind people it's Christmas time.
Well, I'm going with the Mr. Rogers look today.
Mr. That's a good look on you. It's a good look on you. Let's just briefly tell people what's going on, which is nothing. We'll start with Go and Gomez. Now, the reason I bring this up first is because yesterday there was a lot of stuff going on legal-wise. And I read 2 different newspaper articles yesterday about 2 different appeals pending at the D.C. Circuit for over 1 year. One of which is Trump's is a Trump matter in regards to immunity, presidential immunity for some civil suits related to January 6th. And that's still on appeal tonight. And that's been like 13 months. So I said, wait a second, maybe this is not that unusual in the DC circuit, as we have thought it might be. So
are they dealing with the January 6th people, or they're still going on those cases?
This apparently is a private lawsuit against Trump for damages related to January 6th. I'm not really quite sure what it was, but district court found that there was no immunity, and so he appealed to the D.C. Circuit over a year ago.
Interesting.
Where arguments were over a year ago, so it's so we're not that unusual, unfortunately. So there we are. We have no news on that, and sorry, folks. Good news. I want to update people on EB-5 litigation. The deadline for the government to initially or finally adjudicate cases is December 12th. December 12th. And so people ask me, I said, what's going on in my case? I don't know, because it's not December 12th. And we gave them 120 days from August 12th. So we'll find out, and hopefully you'll get an answer shortly if you haven't been adjudicated. About a third of our plaintiffs have been adjudicated. So they got a lot of work to do next couple of days. I have no idea what they're waiting for.
Chuck, let me jump in on the legal kind of news that you were talking about.
Yes, there was something very big yesterday.
Yeah. Right? So we had oral arguments in Wilkinson v. Garland, and that's a case about whether the courts get to review one element of eligibility for this thing called cancellation of removal that happens in immigration court, and it's the extremely unusual and exceptional hardship that you have to show. Why is this important to people? Because it's about some of the similar issues that we're litigating about in our 601 cases and our 601A case, about whether the statute strips the courts of jurisdiction. And one of the things that I thought was really interesting yesterday is that Justice Kavanaugh, in oral argument, he basically, and I have it pulled up on my screen right here, what he said is this: as I've understood it, the discretion is at the second step. So you determine the eligibility requirements, and then you can decide they're eligible or they're not. And then the discretion is the second step, which is whether they actually get the benefit. Well, this is exactly what we as in the immigration advocacy community and lawyers were telling them last year in Patel. And he voted on the other side of that.
Yeah.
A 5-4 decision.
Yes.
I could not believe it when I saw him write this, I saw him say this, which is good. It's good that he's saying this. It's good that he's got the understanding right, but he voted the other way in Patel. Anyway.
Now, why is Patel important? So why is the other way important for us?
Yeah, so Patel is one of the cases that the government's relying on, because what it said was underlying eligibility requirements in a discretionary application are also unreviewable, right? Factual determinations are unreviewable.
But Patel didn't say that.
Right.
Patel didn't say that outside the scope of that particular type of case.
Exactly.
Or adjustment.
Exactly. And Patel was limited to that, to those facts and those adjustments. So anyway, this case, it was interesting because, you never know, but it sounds like they're going to find that the courts do have jurisdiction to review this. And that is a big pushback on the government's arguments that anything touching discretion, anything that's like within
how long they take?
Yeah, exactly, is not reviewable. And so we will be watching this very carefully. It could have an impact on the pending appeal in the Ninth Circuit, depending on the timeline there of their decision. It could have an impact on any of our cases. And so, these decisions will probably come out, I don't know,
spring,
February, March, April, or May, so it's
and
going to be
we'll
a while.
likely have a Ninth Circuit decision before then. But I'm curious whether the appeals court judges are listening to oral arguments like we are.
Yeah.
And they go, wait a second here.
Mm-hmm.
Maybe Patel doesn't say what the government says it says. Justice Kavanaugh clearly doesn't think it says what it says. And, oddly enough, I thought that Justice Jackson was on the opposite side of that.
She was.
This is what immigration does. It makes very strange bedfellows at the Supreme Court. But I think that's going to come down 6-3, maybe 7-2, saying no. And what's crazy, Aaron and I do a lot of deportation work. The idea that to show extraordinary and highly unusual hardship is a discretion. Clearly, the judges think it's discretionary. They don't think it's like a checkbox. Yes, you meet that. It's how they determine it. So if they go as far as saying in a 42B cut, and what's great about this, Aaron, this is like the idea of challenging an NTA. Nobody thought to challenge us for 27 years. And finally somebody said, hell, let's just challenge it. And you get this, and of course it was just, they got laughed out of the circuit court in this case. They laughed them out of it. Supreme Court's going to overturn that. They laughed him out. Of course it's discretionary.
Well, and the attorney for the government yesterday really got herself into trouble because she kept saying there is no legal standard. And the justices would say, we're looking at the standard. It's this extremely unusual and exceptional hardship. And so you have a set of facts that are found. Those are unreviewable. But whether those set of facts laid on to that standard equals enough hardship it's going to be reviewable. I think they're going to find that.
This is important for us, but that case will likely not come out before the Ninth Circuit rules in the current appeal that we are stayed in the 601 case on.
Likely, but not certain.
It's possible they just delay it and let's see what SCOTUS says on this issue, which is fine by us. Because remember, we're still holding immigration accountable when we force them to change their intended process time of 601s, and they've committed that within 1 year of October, they would be at 1 year. We've got that on the freaking record. So now, are they making progress? They're certainly not gearing up like I would expect to meet that standard, but whatever. Next October comes and they haven't done it. I think we have now a slam dunk case because they've said what the processing time should be.
And I just mentioned, as far as the data goes on our cases, and it's consistent with the data that they're publishing, at least on the 601A cases, they are still in May 2020. That is we didn't have any approvals this week. We had an RFE and one other action.
We actually had an RFE. They must have listened to us last week.
Yeah, but it was from somebody who filed in May 2020.
Okay.
So they are being consistent now as far as not jumping all over the place, and they seem to be moving these cases in order. They're still at a 4-year timetable right now, though, or a 3-year timetable, a 3.5-year timetable anyway, which is clearly unacceptable. But that is, they're going to have to start, if they're going to, they're already a couple months in on their promise. They're going to have to start. We should have been seeing already jumps like 2-3 months.
We should have seen bigger jumps than we've seen.
Well, we haven't seen any. They're basically moving, 1 week, they move 1 week. They're not, there's no indication yet that they're speeding up their timetable.
Well, we'll know a lot more when they come out with year-end numbers for their statistical report about how many they did in the last quarter of the year. Because they had simply made no progress through the early part of the year, first 9 months of the year, on the number of cases they were adjudicating per quarter. But we talked last week that somebody in our group had somehow gotten a hold of and spoken to an employee of Hart. Yeah, we're almost fully staffed. Yeah, we're making progress. We're flying. So clearly something should be shaking up there. But Aaron, I'm so glad you brought that up. As somebody who does cancellation of removal cases, now I get to appeal them beyond the BIA? That would be totally awesome. I don't, it's funny, in oral argument, Justice Barrett was saying, yeah, there's very few of these cases. She has no freaking idea.
Have you, did you guys pay any attention to the SpaceX case that came out a couple of days ago? Because that's in a similar vein as far as basically saying that administrative judges really limiting what they.
Well, I actually blogged on this, and so our friend Cyrus did a blog on SpaceX, which is the first of now. There's 2 more cases at the Supreme Court for oral argument, which we're going to be getting Ayla's putting a blog out on. I blogged on it yesterday. But what's important about those, if SCOTUS goes the way that these cases want them to go, immigration court doesn't exist anymore. As we know,
or they're going to have to actually have real appointments of immigration.
Well, they'll have to make them Article 3 judges.
Yeah,
which most of them shouldn't be or should not be Article 3 judges. Absolutely not be Article 3 judges. But it's fascinating because you're seeing a real push, and it's odd because it's conservative lawyers that are pushing this, basically arguing the government has no right, Congress has no right to allow the executive branch to do judicial branch work. Okay, okay, if that's the standard, then we better have a whole lot more judges, is all I can tell you. Well, we don't have enough judges.
They're going to regret this during the Trump.
I agree. I think they're going to regret it big time.
There's a second Trump administration. That's going to be awfully helpful.
Yeah, well, it'll be bizarre. So as far as 601A, we're just waiting. And, I appreciate the Facebook group and everybody posting in there about things they find out. That's actually very, very useful to us. So keep the faith. Keep the faith. Now, Aaron, I want you to talk about our 601 litigation next and where we are with that. I'm going to find my banner, which must be here somewhere. There it is.
Yeah, so our remaining plaintiffs in the 601 case, which the judge in Nebraska dismissed, have gotten back to me. So thank you to you all. They've all said, yes, they're interested in appealing this. Yeah. So the 3 of us and Jesse, we got together and we were trying to figure out how an appeal would work, and it was kind of getting complicated. We're trying to figure out, how would we do the fees? How should it be split up? What if only some people want to participate at a certain fee level? And we just decided, you know what? This issue is too important. We want to have good decisions from appellate courts. We want to fight this case for our clients. We want these families to be able to get back together. And so we're just going to take the appeal on pro bono. There is some paperwork associated with that. So even though we're not going to be charging fees, we are going to need people to sign off on on a representation agreement. That is in the works, Greg, right?
Yes.
Okay. That is in the works. So,
is Jonna back yet?
Jonna is back, and she sent me the template. So
we'll be getting that out by email. Please respond quickly. After we do that, we'll get the notice of appeal filed, and then we'll be rolling on that appeal. But we're really happy to be able to do that. It's, as you know, we've been having these calls. We've been bringing these cases for a long time now, and it's just a passion project for us. So we are happy to be able to keep fighting for you.
And honestly, that the timing of that and the SCOTUS decisions should actually be quite convenient for us, I think. Because when you read the 601 decision, it's like he wanted to rule for us, and he decided, nah, too much work. So he just uses a convenient excuse, I don't have jurisdiction, which he's going to have now. I really believe it. The Wilkinson case came out of nowhere for me. I didn't even know they were arguing it. And then I listened to it. It's, oh my gosh. And by the way, if you are you think SCOTUS is broken, this is if you're going to listen to our argument, this is a good argument to listen to, because they clearly get along.
SCOTUS is Supreme Court of the United States.
Supreme Court. They clearly get along. It's actually a if such a thing as an enjoyable legal argument, that's it. It's actually a really enjoyable, unless you're the government lawyer. If you're the government lawyer, it was not an enjoyable legal argument. Yeah. The government was arguing a case. The fact that the legal theory for their case was the same as one they lost last year. And they were like, didn't you read that case? Didn't we, looking around, didn't we rule on this last year? I don't know. I just thought it was good.
I can't remember who it was. It might have been Gorsuch, but one of them was calling it Groundhog Day from Guerrero Lasprilla. Oh, side note, the listening to them try to pronounce Guerrero Lasprilla is also worth it. But one of them called it Groundhog Day from that, and I was getting a chuckle because they keep calling it Groundhog Day when the deficient NTA issue keeps going up to them, and they keep telling the government, haven't we decided this? Why are we here?
Because you weren't clear enough for the idiots running the government at the unappointable EOIR. That's why you're still here. Mm-hmm. All right, let's jump, Greg, to the Shumalina Astakov case.
Yeah.
This is our U for You case. And
that case, as folks may know, it was moved by the initial court to New York, and we have been we've sent. I don't know if has the government agreed yet on what we had a proposed calendaring for how the schedule was going to work on that case to basically take us to March on that. But we proposed this to them. I think we're waiting on their feedback before we go to the court with it. But a lot of activity is going to happen over the next 16 weeks on that case if hopefully this plan is agreed to. I don't know what else to say on it.
I think they're going to file a motion to change venue again. Honestly, I do.
Probably on there. Yeah, they don't really have a defense in this case other than procedural to try and knock it around to eventually get it to the court that is going to have, they're not going to win in that court either, the place that they want to be. They are sending it there because they want it to go there because they think they will save money. Essentially, that's what it comes down to. Is basically how much can we get away with as far as keeping these fees. Which court is the most favorable for us being able to retain the most of these ill-gotten gains?
Well, you know what? Maybe they don't realize that we're going to make them send a letter on their letterhead to all the beneficiaries and say, "Hey, we owe you $410. Do you really want it back?"
Right.
We're going to make them do that because the Privacy Act says they can't give us the list.
Right.
So, okay, fine.
Right.
Here's the letter.
Whether people,
thank you very much.
It comes back down to whether people automatically get the money or they have to actually go on a website or send a piece of mail into an address. And they're thinking that there will be a certain amount of mail that doesn't make it there because address has changed and they didn't inform the government of it, or people will irrationally say, I'm not, you can keep my money. But it's all a time waster. They're going to lose in the end on this.
All right. So those are kind of the updates. Let's ask some questions today. Daniel, good to see you. Daniel is, there we go. Good morning, fellas. Mr. Sadi, the same way. Any DV 2020 news? We've already talked about that. Thanks for the updates. Is there any DV? We've already talked about that on the reserve visas. By the way, I still remain convinced that our argument on DV 2021 number is a proper and good appeal basis, by the way. We should win that. I'm convinced about that. There you go, Alpha. Can't we just ask the court about the decision timeline? No. You don't get to ask the court. There's nobody to ask because we can't just call the court and say, "Hey, judge, you remember me? I was in oral argument." That's exporting communication. You can't do that. And the government doesn't care, so they're not going to join us in doing it. All right, I saw.
Yeah, let me talk about this. Actually, we had a matter this morning. We were having a lawyer discussion in our office about that. So here's what the challenge has been for a lot of people. And it's more of an issue for Russians than Ukrainians because of sanctions. But we had to, I've been working for basically the entire course of the war in Ukraine with a lot of Ukrainians, but there's also a group of Russians I've been working with and mainly those who are here on J1, particularly on Fulbright scholarships. And the challenge that they've had is, and most of them hate Putin, and they really, and they're not, they have no desire to help the Russian government in any way. They have a home residence requirement because they're on a J1 visa, and they also have been cut off because of sanctions from all of their financial resources from home. So the State Department has been taking this position on those cases that they need to go through the regular waiver process. The Russian government is not going to give no objection letters to any of these folks, particularly political opponents. And most of these people don't have U.S. citizens or permanent residents, spouses, or kids that they would be able to get a waiver through for a hardship waiver. So I had been working to try and get the State Department to do some kind of blanket policy for all the Russians so that they wouldn't have to go through the normal waiver process. They basically said, no, you have to on there and go through a persecution. It's like, a persecution waiver is very expensive. It takes forever. Why are you making all these people go through that for something that and also the president gave this press conference where he was encouraging all these STEM workers from Russia to come to the United States. If they go back to Russia, they're going to be fighting in the Russian army, a lot of them. How is that advancing U.S. policy? Because the State Department always takes this position for those who are not J1, know that much about J1, that they will not waive this home residence requirement to go back to the home country because it's against the foreign policy of the United States. So I've been, several of us have been making the argument that the foreign policy of the United States is not to support the Putin war effort. It's exactly the opposite. So your policy of forcing people to go back for fostering international exchange is actually contrary to another foreign policy interest of the United States, which is not to aid the Russian government in any way, particularly a government that is being sanctioned by the United States right now. So we made all these arguments. State Department said no. So we made similar arguments to USCIS because USCIS has always taken the position that they are the arbiter of who is subject to the 212E home residence requirement, not the State Department. So it's like, okay, if you're the arbiter of this, you can make a policy and you don't have to rely on the State Department. And that actually worked from an advocacy perspective. And happily, USCIS has just changed the USCIS policy manual to say that if there is a war or a conflict, or civil unrest in the country where you're from, we can say that the home residence requirement no longer applies because it's impossible to satisfy the requirement. That is great. They didn't really get, and they also said that they would consult with the State Department if they did this. They didn't really give any more information. So the mechanism for this, how you actually claim that, is you just apply for something that USCIS has to make a decision where they would normally not be able to approve it because of the 212E requirement. And in that, so let's say you were on a J1, you would make an application to change status in the United States, for example, to a H-1B visa or an O-1 visa in the United States, because that's something you're not eligible for under 212E. Or you apply for permanent residency, and when you get to the point when you file, where you would normally be barred from filing for adjustment of status, you would file for adjustment of status and make your pitch that 212E doesn't apply to you anymore because of this memo. There's not a separate application you file to claim this benefit. You have to do it as part of something else, we think, on there. There's not a lot of detail, but that's the way we read it. So if you're a Russian Fulbright or you're otherwise subject to it, that's how you would actually make the claim. Now, in our attorneys, when we were discussing this morning, we're a little concerned that USCIS still might say, yeah, you have to first apply for a persecution waiver and then get denied, and then we'll say it's impossible. I don't think that that's what USCIS meant. And the other part of this was, and I can tell you when we made this pitch to USCIS, we said, these people are broke. They don't have any access to their finances because of sanctions that the United States government imposed. That was a factor in making this decision. Why would you push them into a process where they're going to have to spend $10,000, $15,000 that they don't have to get a waiver so that you can eventually give them something that is in the U.S. foreign policy interest anyway? That's the backstory on it. I don't think that's what USCIS meant. They didn't give a lot of details, but that's so we were actually discussing a case. We're thinking about filing for somebody who might be able to benefit from this new policy right now, but that's hopefully going to benefit some of the people who are in that situation. So that's
all the great information you get from tuning into this podcast.
So that's hopefully what's going to happen. We'll see.
All right. So what news from DB21? We already talked about that. Go and leave a clearer position on the case. We've already talked about that times. Thank you, Daniel. Thanks for fighting for our families. And then we have Nada. I couldn't find any updates in his policy manual. It was a very boring read. Yeah, well, so much is true. That is true about many aspects of the USCIS.
It was announced. I think it was announced also on the USCIS website a couple weeks ago, so you can find it there.
Question: discuss the Sobhani revocation. All right, this is the doctor in Virginia, who applied to renew his passport, and I said, "You're not a citizen." Well, guess what? They're right. He was never a citizen. It's been the law of the land for many, many decades. Really, since the 14th freaking amendment, that you're not a citizen if you're born in the United States if you're subject to foreign jurisdiction. Specifically, you're a diplomat.
Yeah,
you're a diplomat. You have a kid born here. The kid's not a U.S. citizen.
That was one of my first cases as an immigration lawyer, was from somebody that was born in the United States of Iranian parents on there, and that was the lesson I learned on that one.
Yeah, and I've done these for many, many years. Sabani is simply talk to the press. This happens every day. They didn't revoke his citizenship. They just refused to give a passport to somebody who is not a United States citizen.
Right.
The thing is, though, he was a permanent resident. Clearly a permanent resident. That's what the law says. The law says if you're born in the United States, you're not a citizen, but you are a permanent resident of the United States, which you then lose. The question is, did he go back to his home country? I don't know his
is he still journey. Eligible to national?
But he's got bigger problems than that because he voted. He claimed to be a United States citizen. And the way INA 237 works, and 234 works, the only exception to claim to be a U.S. citizen is if your parents are U.S. citizens. So I don't know, other than basically ignoring the law, I don't know how this guy.
Well,
green card.
so he just claimed to be a. Well, I mean, I guess the argument is that he would make is that he applied for the benefit, and the government bears some responsibility because they gave him a passport. So
There's
they
no mercy in immigration law, Greg.
I understand that.
There's no crying in baseball.
I understand that, but they might be able to come up with some kind of equitable relief where they might sort of turn the whole clock backwards.
I don't know anything more than I read, and I think it was a Washington Post article about it, but it did say that he, unfortunately, as a kid, the family moved to another country. I think it was Turkey for years. So
abandonment.
He may have abandoned that permanent resident status that Chuck said that he had. And, to me, without knowing anything special about the case, to me, looking at the case, it looks like a case where they're going to have to beg
here's what I hope.
Open removal proceedings, stipulate to cancellation of removal, and call it a day.
I hope he called Jen Peterson, is all I can tell you. Because if there's anybody could fix this particular down, I don't know if you've done
Sandra Grossman's also good at those kind of cases.
Yeah, I mean, I've done these cases before. The cases I've dealt with generally involve the Mexican people, who were born in the U.S. Their mom has a U.S. birth certificate from a Texas midwife, and it turns out they were born in Mexico. Their parents admit 50 years later when they're renewing their passport for the 10th time. You've seen these. I've had probably 7 or 8 of these clients, just me. So this happens every single day.
Yeah.
What's tragic about this? Now, this guy he could be an EB. He can EB1, EB2. He's a very well-known doctor. I think he's a doctor. And it certainly did not hurt his case to go public. I think that was a good, smart move. Much like Hunter Biden saying, I'll testify in public. I think it was a good move to get aggressive on this case. But I can't fault the Department of State for this. This is not their fault. They're just obeying the law. I mean,
it was their fault to issue the first passport.
Yeah, but he probably got his. Remember, he had one 10 years ago, right? So it's not his first passport. It's probably his 3rd passport or his 4th passport, maybe his 5th passport for all we know.
If they would have caught it the first time he applied, he would have just had his permanent residence and fixed it then, maybe.
Or he would have been nothing. He would have grown up abroad, never come to the United States. So, but at this point, this goes to show you a prime example of why our laws suck. They don't suck because he's not a citizen. They suck because the law doesn't account for errors in the process. It has no forgiveness for mistakenly claiming in good faith that you are a citizen. That's outrageous.
In this case, when the government had an opportunity to fix, the government should have been able to see the mistake. That's like another question on here.
Let me tell you what I did for one of my Mexican clients, a woman who's like 50 years old. She had immigrated her husband.
Right.
Okay. She had immigrated. So he was now a citizen. She tries to renew her passport, and you're not a citizen. They NTA'd her. They put her in deportation proceedings. But she's now married to a U.S. citizen.
Yeah.
So I convinced the immigration judge. This is before Biden. This is a decade ago. Terminate the case, and I'll readjust her. So I was going to get her a green card through her husband that she had gotten the green card for, who is now the citizen. Because what immigration's not going to do is undo the husband's, because he has, they're just not going to do anything on him. Right. And I go to the interview, and they said, well, what's her last legal entry? Well, here, she came in as a U.S. citizen. Here's her passport. Oh they adjusted her. They gave her a green card back. She's now a citizen. So
nice.
This guy probably married to a U.S. citizen. He could just readjust through his wife or his kids, who are probably 21.
The voting thing really should be dependent on whether the person actually knew that they were not a U.S. citizen. If somebody believes that they're and being born in the United States, most people would probably. There are a lot. I've seen the case on there where people just genuinely believe that you're born in the United States, you're a U.S. citizen. That's what we're told in school.
And back in the day, you're a citizen, sure, I'm a citizen. Here's my birth certificate. Well, he has a birth certificate. He was clearly born in the United States, right? People don't understand the nuance. Anyway, that's that case. I thought it was fascinating. But what I loved is how it pointed out, when you really delved into this whole idea of inadmissibility, he's clearly inadmissible.
Yeah,
100% for life. There's no forgiveness for this.
Yeah.
So it's a question of just simply overlooking it. Now, the client that I had got readjusted, she'd never voted.
This is one that would make, I would be thinking that might be a good special bill if you
it's a great private bill. It'd be a great private bill, but
yeah,
getting a private bill through is like doing your own appendectomy.
I mean, but this is one that probably, if you sort of sat down one by one with members of Congress, they would probably say, yeah, that's not right on there. And they would, for somebody who so I would at least try and make the effort if I were trying to counsel them on options.
All right. So we'll be back next Wednesday, same bat time, same bat channel. We may have more news to report next week because Congress is considering some immigration changes in order to give Ukraine money. Yeah, I know it makes no sense either. And these changes are terrible ideas. We won't get into them today because we don't have the details yet. But what we've heard is, as they say in the old country, muy malo. So we'll see you guys next Wednesday. Thanks a bunch.